Can student loans be discharged in bankruptcy? If you are struggling with student loan debt and wondering if bankruptcy can be a way out, you are not alone. Many people believe that student loans are impossible to discharge in bankruptcy, but that is not entirely true. First, let us clarify that discharging student loans in bankruptcy is indeed more challenging than other types of debt. However, it is not impossible. To start the process, you need to file for either Chapter 7 or Chapter 13 bankruptcy. But that is just the beginning. After filing for bankruptcy, you will need to take an additional step called an adversary proceeding. This is essentially a lawsuit within your bankruptcy case where you ask the court to discharge your student loans. The key here is to prove that repaying your student loans would cause you undue hardship. So, what does undue hardship mean? It is a specific standard that you need to meet. In most states, this is determined by the Brunner test, which has 3 parts. First, you must show that you cannot maintain a minimal standard of living for yourself and your dependents if you have to repay the loans. Second, you need to prove that this financial situation is likely to continue for a significant portion of the repayment period. Third, you must demonstrate that you have made good faith efforts to repay the loans before filing for bankruptcy. For example, if you are earning a very low wage and cannot afford to pay your loans while meeting your basic needs, or if you have a medical condition that prevents you from working, you might qualify for an undue hardship, DISR. There have been cases where borrowers have successfully discharged their loans under these conditions. Now, here's an important distinction. Not all student loans are treated the same way. Federal student loans and private qualified student loans are subject to the stricter undue hardship standard. However, some private student loans that are not certified by the school or exceed the cost of tuition and living expenses might be discharged more easily, without the need for an adversary proceeding. If the court decides in your favor, they can either discharge all of your loans, discharge a portion of them, or change the terms of your loans to make them easier to repay. For instance, they might lower your interest rate. Before you decide to go this route, it is crucial to weigh the pros and cons. Bankruptcy can have significant impacts on your credit score and involves costs and time. However, if you are deeply struggling with debt, it might be worth considering. In summary, while discharging student loans in bankruptcy is difficult, it is possible if you can prove undue hardship. It involves filing for bankruptcy and then taking the extra step of an adversary proceeding to make your case. So, if you are overwhelmed by student loan debt, it is worth exploring this option with the help of an experienced bankruptcy attorney.